We are continuing to our preview of the For All Statewide Service Day happening tomorrow. It is your chance to speak with local attorneys and get legal information about your case. Theodora Vaporis is an attorney with the Tuggle-Duggins PA. She's here to talk about estate planning and wills. So we're going to be taking your questions here. You can text them to the number there on your screen, 336-379-5775. All right, we're going to start with the first question. What happens if my family member dies without a will?
Well, if your family member dies without a will, the state has basically, by means of statutes and laws, written a will for you. In other words, they say what's going to happen. And I think the most important takeaway with that is that it's not always what people think. I use the same example oftentimes, but if you're married, I think there's an assumption that if you die without a will, your spouse will get everything. And in North Carolina, that just isn't true. Typically, if a married couple has children and one spouse dies, then the property is shared between the spouse and the children. In some circumstances, that really may be okay, but in others, it can be really problematic. So the example I like to use is, imagine your spouse dies and all of a sudden the house was in the spouse's name for whatever reason, and now you own that house with your 2-year-old child. And so to do anything, you've got to get court involvement. To refinance the house, you got to get court involvement. And of course, we know that 2-year-old isn't paying the mortgage, and yet they have legal rights to the house. So it can create quite a problem. If you're married and don't have children, but you have parents, then it's split between parents and children, parents and spouse, excuse me. And again, that might be okay, but oftentimes it's really not what a married couple wants. So it's really important that you die with a will, so that what you want is what happens rather than the default that the state has set out for you.
Yeah, that's really good information there. So if there is no will or trust, what has to be done for family land to be sold if there are multiple heirs?
Okay, that's one of the biggest nightmares we face, and we face it all the time. So I have estates, for example, where between 2 and my biggest is 42 people own one parcel of property. So if there wasn't a will that directed the sale or directed what should happen, then in this one case, 42 people own it. And so you have to go to the court, and you have to do what's called a partition proceeding, and the court gets involved. It's very expensive, and again, it's problematic. This could be a parcel of property that's worth, $80,000, or one that's worth, $2 million. It's all the same. You still have to go through the same process. So I strongly suggest that people direct in their will what should happen. It's really hard for people to co-own property for like many siblings, and then maybe one sibling dies and then their children own part of the property, and then all of a sudden everybody owns that property together. And as much as I think people think it's wonderful to keep property in the family, it doesn't always make sense.
That is really good to know too. Okay, so the next question, what is a power of attorney and how do I get one in order to help taking care of my aging parent?
So if you want to get a power of attorney for your parents, first of all, our state bar rules require we meet with your parent. And typically we have to meet with them outside of the child or the adult child's purview, so we can make sure that we are doing what that person wants as opposed to what their children are directing them to do. But certainly you can take your parent to an attorney, and it's really important that they're well counseled on the power of attorney, because that's one of the documents. While it is a fantastic thing to have and can be super useful, it's also a great area of elder abuse. So we want to make sure that the person who's signing it is really counseled on what they're signing, and that they are aware if they are giving gifting powers to the person who's their agent, whether they're allowing the agent to pay themselves. And so as long as they really understand what they're signing, it can be a fantastic document. And I do recommend that you have an attorney draft it, and don't pull one off the internet, so that you really know what you're drafting.
That's cool. Yeah, I like that. Okay, so then how often should people review beneficiary designations on accounts like an IRA and life insurance?
Sure. Certainly whenever there's a big life event, a death, a divorce, they should be reviewed and revisited. And then absent that, I would say every just 3 to 5 years, look at them. Make sure you know who your beneficiaries are. It's amazing how when I go through that with clients, oftentimes I send them home with homework to check them and verify, and they're surprised. And if you are divorced and you didn't take your spouse off your life insurance or your IRA, they remain on there. If they're in your will, the statutes kick them out, basically, so they lose their rights under your will, but they don't lose their rights under life insurance or under an IRA. So you want to make sure that you have the appropriate beneficiary designations on that.
Okay, and then my next question, should I add one of my children to my bank account?
So the answer is almost always no. And I know that sounds counterintuitive, especially to somebody who's aging. Adding your child to your bank account, if they are a power of attorney for you, is a good idea. And then they should be listed on there as a power of attorney, not as a co-owner. If you put them on as a co-owner, then your bank account all of a sudden is subject to their divorce, their bankruptcy, their bad credit decisions, and even their just bad decisions. So that's one reason we really don't like to see children on there. And then the second reason is if you have multiple children and you put one on as a co-owner, when you die, if they have a right of survivorship, then they own that account. And of course, your expectation was probably that they would share that with the other children. And we see in most situations that doesn't happen, even though that's what somebody thinks will happen. So we don't want you to presume anything. We want you to actually memorialize it the way that you want it to be. So we think it should stay in your name, and then you can put beneficiaries on it and have it go to all of your kids at your death. But we don't think there should be a co-owner during your life.
I think this is really good.
Absent, of course, there's exceptions to all these rules, but that's the general rule.
You're right, exactly. It's information and then you use it there going forward. Well, we're going to keep going with this, and we have a lot of questions to answer. We're going to come back after this break and we'll have some more.
Thank you.